My name is Asad. I'm an intern at ubAdvocate, and today I'll be speaking on a very crucial topic, that is sedition, and then explain why this law should be scrapped from the statute book. Now, sedition is defined under section 124A of the Indian Penal Code as whoever by words either spoken or written or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excite or attempts to excite dissatisfaction towards the government established by law in India shall be punished with imprisonment for 3 months, which may extend to life imprisonment, to which fine may be added. This law was a colonial law which entered the Indian statutes in the 1860s by the British, who wished to silence and penalize anybody who was a threat to their rule. Back then, various freedom fighters like Bal Gangadhar Tilak and Mahatma Gandhi were slapped with these charges for invoking feelings of nationalism in the people of India. The irony is, however, in the independent India, this provision is being used to bully and terrorize citizens who want to rationally point out the shortcomings of the government. Even after the Supreme Court in the cases of Bhagwati Sharan Shukla versus Provisional Government clarified that it is not sedition to merely criticize the government, it has still been misused time and time again to silence critics with the fear of a possible life sentence and the defamation a criminal charge against them can cause. It can be clearly seen as such, as a large number of sedition cases have been filed in the previous few years against people who were protesting against the Citizenship Amendment Act. The number of cases registered in this sedition has been increasing every year, which, read with the low conviction rate, shows us that it is more of an instrument for harassment than a legal measure to deal with an offense. A total of 93 cases of sedition were filed in 2019, of which only one resulted in conviction. This means this law was wrongly used against 92 out of 93 people. A law this prone to so much of misuse should have no place in our statute book. The kind of people against whom this law has been wielded also tells us a story of misuse. They include students who were protesting against the government policies, poets, journalists, and generally anyone who disagrees with the government. As long as this law remains on the statute book, the governments will be tempted to use it or rather misuse it. Instead of critically analyzing why citizens are driven to dissent, the government is using an iron fist policy with the sedition law to completely shut out contrary views. It is essential for a democracy to have a strong opposition to keep the government in check and not let abuse of power happen, without which there may not be much difference between a democracy which acts for its subject and a dictatorship whose only goal is to stay in power and benefit to whoever is ruling. It is even more imperative nowadays for citizens to raise their voices against the government and its policies and basically act like the opposition, as the current political opposition clearly lacks the power and the support to do so. We should put away this tool to defame ordinary dissent and name it anti-nationalism. The right to peaceful protest without arms is one of the fundamental rights guaranteed by our constitution. Time and time again, it has been seen that this right gets violated by the sedition law, which is again why this law should be scrapped. We should instead come up with more specific laws to counter hate speeches that incite violence, not only against the state or any particular government, but against any protective group also. This law was even scrapped in Britain where it originated, as they saw how this law can be a threat to democracy and will help the people in power to act like dictators. The same has been done in various other countries across the world, and it is about time India also realizes what a threat this law is and scrap it. Thank you.